Hello and welcome to the Rogers Brief for May 20th, 2023. I'm Adam Rogers. Thank you for watching. Thank you for listening. If you're catching this on Apple or Spotify podcast, if you enjoy this kind of content, make sure to like and subscribe, share that with others through your networks and all that sort of thing. What I talk about in this channel, if those are new, is legal stories that are in the news that either have a primary feature of the story or else they're some unexplored angle. I look at cases that are released each week in Nova Scotia and through the Supreme Court of Canada and pick out some of the interesting ones. And there's a few interesting ones this week. National news in two pieces of legislation, the bail reform legislation that was introduced this week by the federal government, and then also there was Bill C-21 firearms legislation that passed Parliament this week. So there's those two, and then there's some cases out of Nova Scotia, a small claims court case, really interesting one, good win for the little guy, and the guy had a collectables collection, and so that was an interesting case. I'll talk about that. There was two brothers fighting in Big Intervale up in northern Cape Breton. One claimed self-defense. I'll talk about that one. A guy was sentenced in Truro for threatening a judge. And then finally, I'll talk about the Kayla Borden Nova Scotia Police Review Board complaint that was dismissed. But first, some sad news. This week, Barbara Ann Reddick passed away. Barbara Reddick would be known to many from the Chase the Ace case out of Margaree. Mrs. Reddick was a client of mine. I represented her in that case. She left us way too soon. She was 63 years old. Many people, she was really unfairly treated in the public eye, I thought, not only during the case when it first emerged, but in some cases since then. I've seen it on social media and Instagram since. But she was much more than her involvement in that case. She was in the military. She spent 23 years in the military. She won a Peacekeeper's Medal for her actions in the Golan Heights. She was considered a second mother to many nieces and nephews. She started Hampers of Hope, which was gave assistance to veterans, and then as the program expanded to others that needed help, she won the Unsung Hero Award in 2021 for her volunteer work in the African Nova Scotian community of Sunnyvale, close to Guysborough here. And she was also a recipient of the QE2 Platinum Jubilee Medal. So quite an accomplished person, and anyway, handled herself quite well through some difficult circumstances a few years back, and I was proud to know her, and just get to know people as a client that in ways that nobody else really does in some cases, and so I had tremendous respect for Mrs. Reddick. And so condolences to her husband Flint and to her 5 brothers and 4 sisters, including Mary Desmond, who's a councillor here in Guysborough, a municipal councillor, so, and someone who was involved in the military as well. Okay, so rest in peace, Barbara Ann Reddick. Okay, so on to the stories of the week. First thing is, this bail reform legislation was tabled by Justice Minister Dave Lametti in Ottawa. Bill C-48 is the number for the legislation. And what this is, it's in reaction to some of the stories that have been out nationally about how it's too easy to get bail for violent offenders, and people have been out on bail and committed further offenses, including offenses against police officers. Well, Lametti, the original Liberal legislation was in reaction to a Supreme Court of Canada decision, which really, because people have the right to bail under Section 11 of the Charter, and so there's some charter issues there with when you try to limit people's ability to get bail. Now, Justice Minister Lametti says this is a targeted approach for repeat violent offenders. Pierre Poilievre, the opposition leader, says it doesn't go far enough. Canadian Civil Liberties Association says it will not make the public safer. They say that crime rates are down and bail denial is up 400%. Big problem in Toronto and other parts of Ontario. I know the bail system there is really overwhelmed. That's more of a resource issue than a state of the law issue, although, of course, one can affect the other. They said 2/3 of people that are in provincial jails are not convicted of a crime. Well, that can be, there's some statistics there. They're a little misleading in some cases. Like if people are, get arrested and there's great certainty that not only have they actually committed the crime, but also that they're going to get jail time, then, it's not unusual for them to be denied bail or to refuse or not even ask for bail before plea. You accumulate time that'll go against your sentence. So it's not that they're innocent, it's just maybe that they're not yet proven guilty in some cases. So wouldn't read too much into the CCLA statistics there. So what are the changes that they're introducing in this new legislation? Well, there's 5. One is reverse onus. So normally it's up to the Crown to prove why you should be held in jail for certain offenses, and if you've breached a condition, then the onus is on you to show why you should be released. Reverse onus. So for violent offenses involving weapons, if the person has had a similar conviction within the last 5 years, well, that's a reverse onus now. If a person has unlawful possession of a loaded or prohibited or restricted firearm, or they've done a break and enter to try to steal a firearm, then that's a reverse onus. There's a reverse onus for intimate partner violence cases, certain ones. For breaches of conditions that involve a firearm, there's a reverse onus. And the 5th one, this is legislated to say what's already happening effectively, which is that the judge should consider an accused's history of violence and prior offense. Well, that all happens anyway. There's a review time frame in the legislation that in 5 years the legislation will be reviewed by a future government. To me, there's lots of people talking on both sides. I don't think this legislation is going to make much of a difference at all. In those situations where there's now a reverse onus, it was very unusual for people to be granted bail in those cases anyway. If you have a violent offense involving firearms and you've had a recent violent offense involving firearms, well, pretty unlikely that you're going to be granted bail. So, in those rare cases where somebody could meet the reverse onus, well, then there's other nuanced circumstances that is proper for a judge to consider. But I don't think this is going to really change the outcome of very many cases. So and it's in response to not only pressure from provinces and opposition parties, but it has to stay within what's been described by the Supreme Court of Canada as, well, you should be granted bail unless there's really strong reasons not to. Okay, so that's enough of that bail reform legislation. We'll see how that goes as it makes its way through Parliament. Next one that has made its way through Parliament after a long process is Bill C-21, and this is the firearms legislation. Not much to say about that other than it was the Liberals, NDP, Bloc, and Greens that voted for it. The Conservatives and 2 Liberals from rural ridings voted against it. It's been controversial throughout, reworked several times. It defines assault-style weapons for future developments in different firearms, I guess. There was a point where it listed, hundreds of different firearms and banned some that were being used in hunting, and so that created a lot of controversy throughout. Well, it was a few months ago. So now assault style is going to mean something that is not a handgun, but is semi-automatic and designed with a detachable magazine of 6+ cartridges. So we'll see how that develops as things come along. Okay, so those are the 2 pieces of legislation. I'm going to talk about a few cases that are in the news, and these are Nova Scotia cases in all 4 instances that I'm going to discuss. First one is this small claims court case. It came out a couple of weeks ago, but it wasn't actually Jordan Bonaparte, who I go on his podcast Sunday evenings with the Nighttime podcast, mentioned this small claims court case to me. It's Chedre versus McLaughlin. Chedre being the landlord, and had locked out McLaughlin from his apartment that he was renting, and the Residential Tenancies Board found that was an improper act. Well, what the landlord had done was go in and clear the place out, did a lot of damage, and so McLaughlin claimed that it was improper that he was locked out and that he suffered damages. Well, at the Residential Tenancies Board, he was successful, but only to the extent of $1,371. Some return of deposits, some moving expenses, and some damage to furniture that could be proven at that level. the thing is, he had a whole bunch of collectibles, claimed like $20,000 plus for collectibles, these cars, action figures, all these things that were in his apartment, he claimed. Problem at the Residential Tenancies Board is he had no expert evidence, no evidence really of what the values were other than his own. What happened? The landlord appealed. The landlord was forced to pay $1,371, appealed to small claims court. And this was heard by adjudicator Dale Darling. And what happens at small claims court, it's a hearing de novo. So you're not, unlike a regular appeal where you're bound by the trial record, when you go from residential tenancies to small claims, you just start over. So what did Mr. McLaughlin do? He got an expert report this time. He got a guy, Jimmy Romaine, who is somehow an expert or was accepted as an expert by the small claims court, and produced a report that said if the collectibles that were shown that Mr. McLaughlin owned were in good condition, then they'd be worth, $20,000 plus. And they're now in their damaged state, probably worth, $4 something. Okay, so how do you prove what kind of condition they were in? Well, here's the irony. The great irony was it was photos from the landlord. The landlord had gone in when they locked the guy out to take photos to show what a mess the place was. Well, yeah, there was it was a little disorganized maybe on the floor, but what the photo also showed was on the walls, these pristine, still in the boxes, collectibles, cars, action figures. And so the adjudicator of the small claims court said, okay, I've got an expert report. I have these photos that show that they were in great condition, and awarded $15,000 for the collectibles. So bad move by the landlord, but to appeal and then to produce the photos in that case really helped out the claimant in that case. So good win for the little guy there. All right, next case I want to talk about was this Bradley Sturgeon. Just mention it. It was a threats case, and it's unusual. You get this. I mean, it was threats to Judge Alain Begin, the Provincial Court Judge that sits regularly in Truro. And Bradley Sturgeon, 53 years old, this is in December 30th of last year, tried to renew his license at the DMV and found out that his license was suspended because he had a DUI. Well, I don't know how he couldn't have known that, but in any event, figured out that his license was suspended, and he's like, oh yes, that was Judge Begin that convicted me of that, or whether he pled guilty or was convicted, it wasn't clear from the decision. And at the DMV, he said he was going to beat up Judge Begin. Well, so they called the police and reported that. But then Sturgeon actually did go to the courthouse in Truro. Judge Begin was not there at the time. The sheriffs dealt with him, but repeated what he had threatened and was charged with uttering threats. So what do you do there? You can't just have the judge next door necessarily. They got an outside judge from New Brunswick, Judge Claude Hachet, New Brunswick Provincial Court, and sentenced Mr. Sturgeon to conditional sentence order, which is house arrest, 2 months of house arrest, 2 months with a curfew, and a year of probation after that. So for those threats to Judge Begin. All right, next case. King versus RV MacEvoy. And this is a decision of Judge Peter Ross out of Sydney. First interesting part was in one of the first or second paragraphs of the decision, Judge Ross noted that he had also heard the preliminary hearing. So in serious charges, you can have a preliminary hearing in provincial court to determine if there's enough evidence to go to Supreme Court for the trial. And usually there is. It's a low bar to cross. But you hear the preliminary hearings done at provincial court level, and then your trial will be at Supreme Court. Well, sometimes people can re-elect to provincial court, have their trial held there. It's usually done quicker, and I don't know. People make those decisions for different reasons. Supreme Court, you can have a jury trial. Provincial court, you can't. Anyway, they re-elected back to provincial court, and it was Judge Ross that had heard the prelim, and he also ended up hearing the trial some months later, maybe. But anyway, both lawyers agreed to it. It was Crown, Kevin Matthew Finnerty from Sydney, good Crown there, and Kevin Patrick with Legal Aid in Port Hawkesbury on defense. So an interesting move there. Anyway, the situation is more interesting though, which was two brothers, Ernest and Alistair MacEvoy. Ernest is 61, Alistair's 58. Alistair was going to visit his 80-year-old mother in Big Intervale. He drove from Shedicamp on his motorcycle. This was in June of 2020. And Ernest had just moved back the previous September to live with his mother, who was 80 years old. And the two brothers, it said in the decision, had not spoken in 20 years. Okay, so didn't explain why, but clearly there was something going on there. And Alistair went in to visit his mother. Ernest was out whippersnipping. Alistair comes out. There's grass shavings all over his motorcycle, which he had just cleaned. And so they get into an argument over that. Words exchanged. Alistair said, you're mooching on your grandma. Your 80-year-old mother's probably in there making you lunch right now, and those sorts of things. And so Ernest decides he's going to go to the shed, and he gets a 12-gauge shotgun, pulls it back out, points it at Alistair up and down, and shoots him in the leg. He claimed that Alistair had gone towards him and was threatening, had his fists up, and he's bigger, and he knew, Alistair was bigger and he could probably take him if it came to that. And he was worried, so he shot him. Well, the judge didn't accept that at all as a self-defense argument, or that actually happened. There was some distance, either 20 or 50 feet still between them. So Alistair didn't want to concern his mother, so he had some shots. He could still feel his legs. There was blood going down his legs, but he got on his motorcycle, drove 5 kilometers to a third brother's place, actually his grocery store. And someone called 911, and they got that all dealt with. Anyway, so Ernest, guilty of aggravated assault, and so will be sentenced at a later date. So anyway, kind of a crazy thing with family members up in Big Intervale. All right, last case I want to talk about is Kayla Borden, and this was a case. Now, the decision itself is not public, and that's I guess an important place to start, because we don't know exactly what's in the decision. We just see the CBC reported on it. The other interesting part is that Kayla Borden's lawyer provided the decision to the CBC. Okay. You would normally, maybe they were keeping in touch and they were publicizing the case, and you're happy to provide the decision. It's nothing wrong with doing that. But given what's in the actual decision, I have a few questions about it. So let's go through that. So what happened was, Halifax Regional Police was looking for somebody that had fled a checkpoint. They thought there was radio broadcast evidence that Kayla Borden was driving without lights. They stopped her vehicle, thinking that might have been the vehicle. The stop took less than 1 minute, and that there was no evidence that the police knew Kayla Borden's race until they were at the side of the car. So in the decision, it said by the Nova Scotia Police Review Board that with her strong conviction of police racism, she refuses to accept the rationale behind the events of that night, even with full and clear tested evidence. And then further, there is not an iota of evidence that conscious or unconscious racial bias or systemic racism had anything to do with the pursuit and arrest. So, pretty strong words in the decision. But in the CBC story, the Miss Borden's lawyer, Asaf Rashad, who's only a couple of years into practice, recent call. So some questions about that too. I mean, presumably, I don't know, maybe that was her first choice of lawyer, but maybe she went to others and wasn't getting accepted, and this guy agreed to take on the case. To push it to judicial review, I can't imagine, because they're going to be hit with costs on this decision. The Police Review Board will award costs, I'm sure, against Miss Borden. And judicial review would cost a lot of money too to do that. And how is that being funded? Hard to know. Hard to know how that would benefit anybody to take it to judicial review. The officers were represented by Natasha Najawan, who people might recognize from the Mass Casualty Commission, and HRP itself, the regional police, represented by Andrew Goff. So anyway, I don't see what kind of judicial review, why anybody would take it to another level given the strong wording of that decision, but maybe she has her reasons or something else. But it doesn't seem like there's anything there. I don't know if the Police Review Board is going to post that decision at some point. I think they should, given the publicity of it, but we'll see. So that's it for this week. Covered some cases, some interesting cases out of Nova Scotia this week. Some legislation going through Parliament in Ottawa, and the relatively young, untimely, and sad death of Barbara Ann Reddick. So, former client of mine, and so rest in peace to Barbara Ann Reddick. And for everybody else, we'll see you next time.